Welcome to Forum at 360. I'm your host, Matt Miller. Our guest today is Walter Carpeneti, a retired Alaska Supreme Court Justice. He was appointed to the Supreme Court in 1998 and served until 2012. He served as Chief Justice in his last 3 years with the court, and we'll be discussing Alaska's judicial system today, how judges are selected and why regular Alaskans get to vote on which judges get to keep their jobs. Thanks for joining us on Forum 360 today.
Thanks for having me.
First of all, before we get into the kind of the nitty-gritty of different things that part of the process as far as selecting judges and the retention process, I wonder if you could kind of frame it for typical Alaskan. Why should Alaskans care about it? What difference does it make who is selected for the bench?
Well, I think Alaskans should care because at any given time, any one of us can end up in court under any kind of circumstances, not just a criminal case, but a contract dispute, a landlord-tenant dispute, any kind of situation, a commercial dealing, or even end up in court as a juror. And I would think that any citizen facing the prospect of being in court would want to have the best assurance possible that they're going to get a fair hearing, or if participating as a juror, they're going to see a proceeding about which they can be proud, that serious people look at the facts, consider the law, and try to apply that law and come to a correct decision. And we all have a huge stake in a justice system that works. You know, when people consider countries around the world, one of the most important things to decide how a country is functioning and whether it's functional or dysfunctional is to answer the question whether it has the rule of law, whether outsiders as well as citizens who find themselves in a dispute can go to a tribunal that is fairly constituted and that will give a fair and impartial decision. And so even if somebody doesn't expect to be in court, they might, and even if they're never in court, they want to understand and know that they're in a society where rules apply and rules are followed. And if they don't like the rules, they can try to have them changed through the legislative process, but there's a system that's in place that guarantees their rights and guarantees that they will be treated fairly.
You mentioned the contract dispute. There's other things, traffic ticket, for example, divorce, custody?
Sure. I mean, any time that citizens find themselves in a legal dispute, they want to have at least, I mean, it's a miserable situation to be in, but you want to at least have the assurance that the system that you're in is a fair one, that will listen to you, that will consider your arguments, that will determine the facts, and then apply a law that applies to everybody the same way to come to a conclusion.
Now, at statehood, Alaska implemented what, at that time, was a fairly unique system for selecting and retaining judges. Can you describe that for us?
Sure. It's referred to as a merit selection system, and when a judicial vacancy occurs, it's not a matter of an executive saying, I'm going to appoint this person and that's all there is to it. It's not a matter of people throwing their hats in the ring and having a contested partisan election. When a vacancy occurs, a person who's interested applies to the Judicial Council for consideration to be a judge. The council goes through a really exhaustive process. You fill out about a 20 or 25 page application. You answer questions about your education, about what you've been doing in your life as a lawyer. You name cases that you've been involved with, and the council then goes and investigates, talks to the judge in the case and the lawyer on the other side. The council polls every lawyer in the state of Alaska on every judicial applicant in 5 areas: judicial competence, professional competence, integrity, diligence, suitability of the person's experience for the application, for the position for which he or she has applied, and temperament. The council looks at bar disciplinary records, looks at credit reports, looks at criminal records. Hopefully we don't have a big amount of material to check there. As I said, it goes to the last 5 cases that the person was involved with and talks to the judge in the case and the lawyer on the other side. If the applicant for a judicial position is a judge himself or herself, it goes to the lawyers that appeared in front of that judge. It's a really exhaustive process, and there's an interview. And at the end of that time, the council is charged under its constitutional duty to send 2 or more names to the governor, and they have to be the best folks that applied. And so you don't know, depending on how many people applied, whether you're going to have 2 names that go up or 7 names that go up. And it really depends on what the whole field looks like. But that's the first half of the process. Then once the governor is forwarded the names, he or she has 45 days to make a selection. When that selection is made, that person is sworn in as a judge. And then the further check that was built into the constitutional system is the requirement that that new judge stand in the first general election that happens.
I don't mean to cut you off here, but
Sure.
I wanted to we can get to the nitty gritty a little bit later on that, but I seem to recall that this has been dubbed the Missouri Plan. You recall how that got started and how that became a way for selecting and retaining judges.
I think Missouri was one of the first states to use a system like this.
And the council, the Alaska Judicial Council, that's part of this whole process. Can you tell me a little bit about the body?
Sure. The framers of at the Constitutional Convention debated this pretty seriously, and they came up with a plan that involves a lot of checks and balances and compromises. They first said, I don't know if they first said, but one element of the council are the lawyers. There are 3 lawyers who are appointed by the Board of Governors of the Bar Association. Historically, the bar has always done a poll of all the lawyers in the affected district, and it has always followed the results of the poll, although the board is not legally required to do that. So 3 of the members, and they have to come from different areas of the state. They have to be chosen with due consideration for geographic distribution. So there's 3 lawyer members that are appointed by the Board of Governors of the Bar Association. There are 3 public members who are appointed by the governor and confirmed by the legislature. They have to be confirmed by the legislature. So you have 6 members of the council. There's a 7th member, and that's the Chief Justice, who sits ex officio as a result of his or her position. But the chief doesn't vote unless a vote is necessary to change the result of to get a result. Typically it's said unless the chief doesn't vote except in the case of a tie.
So in other words, 3 and 3 may be deciding on, there may be a split vote on candidates.
Exactly, and the reason I don't use the term in case of a tie is the chief also votes in the case where the vote would change the outcome, and that occurs if you've got somebody abstaining or perhaps missing a meeting, which almost never happens. But if you have a 3 to go through and 2 not to go through, then the chief would vote in that case, because you need 4 votes for the council to take action. So the chief votes in the case of a tie, or 3 to 2 to send someone through.
And you mentioned this a little bit, you touched on it earlier, but there's a kind of an investigative process in which anybody who applies for to be a judge has to go through a background check, credit checks, and that sort of thing.
Yeah, I'm kind of an investigative process, to use your terms, is stating it mildly. It is a long and grueling process. I didn't mention you need a writing sample, which is fairly substantial. I mean, if you are thinking about applying for a judgeship in Alaska, you think carefully about it, because it's a very serious process. It takes a long time. Your life is on hold for 6 or 8 months while the process works its way through. Because once the applications come in, that's just the beginning. The bar poll takes a long time. I mean, every lawyer in the state is polled on all of these subject areas, and then those results have to be collated, and they have to be gotten out to the people. And then there's the interview process. Every person is interviewed by the council, and it can be either a public or private interview at the choice of the person who's applying.
What's the interview like? What does the council ask the prospective candidates?
Well, I can tell you it always begins with the Chief Justice asking the same question, and that is, would you tell us why you've applied for this position? And then we go around the table, or the council goes around the table. It starts with a different member each time so that there's no patterns that develop that way. And individual council members ask those questions of the applicant that they think are appropriate, often in light of the application materials that they have in front of them. For example, they might say, I notice you've practiced a lot in this area of law, but you seem to have holes in these areas. You've applied for the Superior Court. That's a trial court of general jurisdiction. How can we be assured that, that you'll be able to do a good job in these areas you haven't practiced in? Or there might be a pattern of comments on the bar poll, because lawyers have the opportunity to write individual comments as well as grading the people in these 5 areas that I mentioned. And there might be a pattern that's disturbing with regard to tendencies to shoot first and think about it later, or whatever. I mean, use your imagination. And so the applicant will be asked about that. They're often asked about their attitudes towards things that the council members are interested in, public service or whatever. I mean, they can be very broad-ranging.
And not everybody can be a judge. I mean, in this state, there are qualifications. You have to be a resident for a certain amount of time, practice law, be a member of the bar. Is that right?
That's correct.
Okay.
You have to be a member of the bar, and you have to have practiced for a certain number of years, depending on the court that you're applying for.
Why is that?
Well, I think those minimum standards were set so that there would be a sense that the person has at least some familiarity with the practice of law in the area. The periods of time are pretty low, and I feel like I'm taking a test, and I've been away from school for 2 years. I think it's 5 years for the district court, and it's 5 years for the Superior Court and 8 years for the Supreme Court, I think. I mean, they're relatively short periods of time when you consider what you would hope somebody's familiarity would be with the legal culture, with the law of the state, with just everything. So.
And there are some other things that the council goes into, like community service, also any sort of discipline that they may have been subjected to while they were an attorney, that sort of thing.
The council will frequently go into those kinds of issues.
And then there are public hearings on a potential candidate, right?
There's, on every judicial application, the council holds public hearings. And so the public has the right to come in and give their opinions, pro or con. Historically, I will say that for judgeships in the smaller communities, those are really well attended. In the larger communities, not so much. In Anchorage, there might be 3 or 4 people that would show up. In Kotzebue, when we went out there for the Superior Court, there were at least 35 or 40 people.
And you mentioned when the Supreme Court Chief Justice acts as an ex officio member and only votes when the outcome needs to be determined. How often does that happen, the so-called ties that happen?
It's pretty rare. Before this interview, I looked back at the number of ties that occurred that were of a particular type, and it's because this issue has been raised by some folks who want to change the way we select judges, which I think is a bad idea, to change it. But the issue that's raised is, well, it looks like it's even 3 lawyers and 3 non-lawyers, but it's really 4 lawyers, because the Chief Justice, by definition, is a lawyer. So it's really 4 against 3, and therefore it's easy for the lawyers to sort of control the whole process, and it's kind of an inside baseball sort of thing, and we shouldn't have that. So I went back and looked. They started keeping records of all of the actual votes in 1984. So we have a 30-year history. During that time, there were 1,136 votes on applications for the judiciary and judges who were up for retention election. And the council makes a recommendation on every one of those. I didn't get to explaining that, but there were 1,136 votes in that period of time, and there were 15 of those 1,136 in which the 3 lawyers were on one side and the 3 non-lawyers were on the other side. So about 1% of the time. And of those 15, the chief sided with the public members 5 times and with the lawyers 10 times. And so basically the number of times that the Chief Justice sided with the lawyers against the non-lawyers in a 30-year period was 10 times, or about once every 10 years. So it struck me, once every 3 years. So it struck me as not a very large amount of times. It's really tough for me to conclude that there's any kind of problem there. The argument goes on, it's happened more frequently recently than it used to before, but still it seems to me to be such a low number that it's not too critical. Now, what you asked me was the number of times that there were tie votes altogether, and I'm not sure of that. But the thing that I do recall from having looked at those numbers is the number of times that the council members are unanimous or unanimous but for one is about 75% of the time. And most of the time, sort of the truth emerges from what is a really detailed and painstaking process. I mean, the council finds unanimity way more often than it disagrees.
At least 2 names to be sent to the governor for
That's
a potential seat. And they're not just qualified for the bench, they have to be the most qualified?
Yeah, and that's a really important point, and one that I think causes some people who look at individual council votes some heartburn that they don't understand. And what the framers said was, and they used the term in one of the debates, and it's come to signify this really important point. They wanted the council to send what they called the tallest timber to the governor, the best applicants to the governor. The thinking being that it's a 2-part process. It's a merit process and it's a political process. And I don't use the term political in any negative way. I mean, politics is the formulation of policy for our state, and hopefully it's good policy, but it's an honorable thing to do. There's nothing wrong with politics as such. And the process is, let's make sure that we send really good candidates to the governor. And then when it's in front of the governor, of course the governor is a person who's been elected by the popular will, and he or she represents a particular philosophy or a particular attitude, a particular political view, and of course that person is going to look for the person that's closest to that particular view at that time, and that's fine, and I think that's what the framers intended. But they also intended that that choice be narrowed down to the very best people that the council could find. And so you get the situation where sometimes there's 2 names that are way up there, that their bar polls are off the charts, their interviews are very strong, their records are very, very solid, their writing sample is just something that you just love to read because it's so well done. And then you might have some others that, you know, they're pretty good. They could do the job, but they're not the tallest timber. And the way the council has seen it for years now is that it should send the best names to the governor. And you get really different results depending on who is in the panel that's applied. The first time that I was the Chief Justice and a position on the Supreme Court came up, there were 25 applicants. A few dropped out before the interviews. We interviewed 18 or 19. We sent 7 names to the governor. That's a lot of names for the governor to choose from. The last time that I was, and I think there were only 2, my memory's getting faulty, but the last time that I was on the council and the Supreme Court position was up, there were 12 applicants. There were some really strong applicants, and the 2 names went to the governor. And we were criticized for that. And in fact, I cast the only no vote that I cast when I had to break a tie during that time. And I did it because, not because the person that I voted no in regard to was not qualified. I thought he was qualified. But under any objective analysis, he wasn't at the same level as the 2 names that went through. And I felt very bad. You know, it wasn't a hard decision rationally to make. It was a terribly hard decision to make emotionally. I mean, I admired this judge. He had done great work in a crisis situation out in Bethel and volunteered his time and gone out there and was a real team player, a smart guy, up and coming. And the standard is always that the executive director calls all of the applicants immediately, even before we tell the press or anybody else, because we think that's the decent thing to do. And I said to the executive director, let me make this call because I don't want him to learn that he lost on a tie vote by the Chief Justice and think anything other than what I'm going to tell him, which is, I hope you apply again. I think you're a strong candidate, but under our standard of sending the tallest timber, I couldn't put you in that group with the two that went up.
Reminder, you're watching Forum at 360, and we're talking with Walter Carpeneti in regards to the selection and retention of judges. Also a reminder for our studio audience, if you have any questions, feel free to step up to the mic and we'll see if we can squeeze you in. Let me focus a little bit more on the personal aspect. When you worked in Alaska, and I believe that when you started in Juneau or in Southeast as a public defender, and then you transitioned to as a private attorney, what made you decide that you were going to apply for the Superior Court bench?
Can I go back on the predicate? I actually started in Southeast as a law clerk to
okay.
John Diamond on the Supreme Court, which I'm very proud of, so I always like to mention that. I was gone for a couple of years while my wife was in law school, and then when I came back I was in the public defender office for 3 years, and then I had a private practice for 3 years. And what got me to apply was I had become a member of the Judicial Council. I had put my name in because a vacancy came up and it was suggested that I might be interested in doing that. So I sat on the council for a couple of years, and it really got me interested in the whole notion of being a judge, which I had not thought about before that time. And then, strangely enough, there are 2 Superior Court positions in Juneau, and they came open at approximately the same time. I mean, the first one became evident because Alan Compton had been, who was a Superior Court judge, had been appointed to the Supreme Court, so his position became open, and at about the same time Judge Stewart announced that he was going to retire, and he'd been a judge for a long time. And I thought, if I'm going to do this, I should probably put my name in now. So I resigned from the Judicial Council and put my name in.
Why? I mean, what made you decide to make that leap?
Serving on the council for a couple of years, I got to see what went into it, and I was inspired by the opportunity to do things that would be helpful to other people. I mean, I really think judging is a public service, and I don't say that this applies to me, but I think it would have, but I know that with regard to a lot of people, I mean, there's people that leave jobs in private practice and come in and work in the judiciary for a fraction of what they were making before. It's a public service job, and I liked the fact that it was a public service job and that you could do something that would be helpful, and it seemed like a good job. It seemed like a good and honorable thing to do.
When you put your application in, what was the process like? How did you like being scrutinized and your background gone over with a fine-tooth comb?
You know, I don't resent it, and I don't think there's a single thing wrong with it, but it is a tough process. I mean, you kind of lay your life open, and council members ask really tough questions across the board. I mean, they really want to find out what you're made of, why you're doing it, what your motives are, and I think they should. I mean, it's a public job that's an important job, and they should be as clear as they can be, and they should know as much as they can about the people that they're putting into these positions, which have a lot of authority. So I found it to be a tough process.
And then when you were appointed to the bench here in Juneau, what was the work like on a day-to-day basis?
I thought it was a hard job. It was, you know, a trial court can tend to be kind of crazy. There's a lot of things going on. You have to be a good time manager. You have to not agonize over things. You have to not want to sit and think about things too much, all of which I score poorly on. I mean, all of those scales. So I found it hard for the first 3 or 4 years until I learned to just realize that at a certain point you had to let it go. You had to get on to the next one. You had to do the best you could and then go to the next case. And I think I got a little bit better in terms of time management. I was a trial judge for 17 years, and I was always, you know, kind of up against the time limits for getting cases decided. I always was worried when, because judges are polled, I mean, lawyers are polled on judges all the time, not just for the selection, but every time you're up for retention election. they do polls on you. And I was always worried, I'm going to get low marks for diligence. And I worked really hard at the job, but it was tough for me often.
And if you take your time on a particular case or an opinion, for example, you get your salary docked. Is that right?
Yeah, you have to sign an affidavit every 2 weeks saying, I've had nothing under advisement for more than 6 months. And if you've had anything under advisement for more than 6 months, you can't sign that affidavit. If you don't sign the affidavit, you don't get paid. And 6 months sounds like an eternity, and I know it is for people that are waiting for a decision, but I'll tell you, it's not that hard for this set of facts to occur. You have a monster summary judgment motion, which has 14 subpoints, and you've got really great attorneys on both sides, and it's a tough area of law. And you think you've got an idea when you go into the argument, and then you have a really tough argument, a really good argument, and you come out and you think, oh, this is going to take some time. And that happens on a Friday. And on Monday, you start a jury trial. I once had a jury trial that was supposed to take about a year. It was the John Kenneth Peele 8-count murder case that I inherited when it was a hung jury in Ketchikan. Fortunately, it only took about 6 months to try. But just before the Peele trial started, I had a summary judgment of the type that I described to you a moment earlier. It was, you may remember the case, well, you probably weren't here, but it involved a newscaster who said some things and was sued by a trooper for libel and slander, and it involved all kinds of federal and state constitutional issues about freedom of speech and press rights, and it was just a nightmare of a case. It was a tough case, and it was a tough winter for the Carpeneti.
So it's really easy for work to back up, right?
Yeah, yes. I went in several months later with a number of paychecks that I got all at once because I couldn't collect them because I had, I think I went about a month past or maybe 6 weeks past because the Peele trial was just, it was an all-consuming experience. We started in the morning, we went till 1:30, the jury went home, and then every day both sides filed several motions, and my law clerk and I usually would find ourselves trudging up the hill from the federal building at about 11 at night. I'm not making this up. It was completely all-consuming for everybody. The lawyers probably worked harder than we did, but I couldn't have worked any harder than I did. And I had this motion pending the whole time. So you can get into a doomsday scenario when.
I know it's probably not very much in the grand scheme of things, but when you become a judge, when you transition from an attorney to a judgeship, doesn't your social life pretty much take a nosedive or take a weird turn?
Yeah, it does, because if you think about it, when you're in whatever profession, I assume most people hang around a lot with other professionals or other people that do what they're doing. So lawyers tend to hang around with lawyers. You have friends as lawyers. Then you become a judge, and you really don't want to be having people who are appearing in front of you in court over to your house for dinner because, how would that look? You're in a trial with one of them, and the other one, is feeling kind of on the outside. So you largely cut off social functions like that unless there's going to be a whole lot of people present. And there's so many times when you don't want to be around folks who are talking about their cases because it might be a case that's in your court. So it does tend to be kind of a constricting and narrowing sort of experience. And I'm not complaining. It's a great job. It's got a lot of things going for it, but there's some downsides too.
You're watching Forum at 360, and we're talking with Walter Carpeneti about the judicial selection and retention process. And policymakers have called Alaska's system, constitutionally speaking, one of the best in all 50 states. Would you agree with that?
I would, and I'll tell you, it's anecdotal, but one of the things that you do when you're the Chief Justice of the court here is that you attend the Conference of Chief Justices, which is a national organization, and as you might imagine, it's made up of the Chief Justices of all the 50 states. And oh boy, I heard an awful lot at those meetings that made me just cringe, and about how tough it would be if we had a system like that, how tough it would be to be a good judge in a system where, every 2 years or 4 years or 6 years or whatever, you're out there having to raise hundreds of thousands or millions of dollars for a campaign. And I had lots of those Chief Justices tell me how much they admired the system that we had in Alaska and how well it seemed to be functioning.
If you go outside to some states right about now, you're going to see yard signs, TV, radio ads, newspaper ads for county judges, Supreme Court justices. They're going to be raising money from attorneys, corporations.
Yeah, I mean, when you think about it, who's going to contribute to those campaigns? It's either entities, organizations that have a lot of business in court, corporations or unions or whoever, but entities that are going to be in court, or the lawyers that represent them. And you know, the idea of walking into a courtroom and seeing, now this side contributed $25,000 to my campaign, but this side didn't, or contributed to my opponent, and saying, but that's all going out of my mind because all I'm going to do is make the decision based on the facts and the law. I think that, I mean, judging is a tough job, but to add that kind of complication to it would be anathema to me. I think that would be horrible.
And if you walk into a courtroom and you're a party in a particular case and you're not a contributor to that particular judge, then there's no expectation that you're going to have a fair hearing, right?
You know, it's either that or else you've got a judge who wants to appear so fair that he or she bends over backwards to not be unfair to the side that contributed to the opponent. I mean, it just complicates an already difficult situation way beyond what it should be complicated. It's probably not grammatical, but.
Other states which have adopted the Missouri model, the Missouri plan, they're also sort of chipping away at the merit selection process. Is that something that we should be worried about at this point?
Well, I think other states need to decide for themselves what's best. The only way I would be worried about it in terms of Alaska is if the argument were made that, well, another state is adopting partisan elections, so we should do it. I don't think that's a good argument. And I'm not sure that there's as much chipping away at Missouri plan type states as there are many states that are considering it and moving towards it in some degree. I mean, I think it's a pretty fluid situation, but I don't think that what other states do is critical to me. What's critical to me is what Alaska does.
And I know this is kind of out of 5th grade, 6th grade social studies type of question, but why do we need an independent judicial branch?
Well, I think there's a number of reasons. I think it's important that the first thing that I said, when people walk into a courtroom, that they believe and that it is true that they will get a decision in their disputed case based on a dispassionate analysis of the facts and an application of the existing law to those facts and coming out with what the decision should be, apart from any political consideration. So I think that's really important. Secondly, I think that the idea of judicial independence is important because there are some times when, under our Constitution, judges have to make decisions that might not be what the majority wants, but they have to have the independence to read the Constitution and to look at the case law from higher courts where that's appropriate, and to make a decision that follows the law and maybe not necessarily what the majority at a particular time might think. And there's just all kinds of examples where courts over the last 50 years and before that have protected the rights of minorities that might not have won at the ballot box. I mean, where judges are literally making a decision that would not be the decision that's made by the majority, but they have an obligation to do that because the Constitution, our fundamental document, promises certain things and guarantees certain things to people, even if they're not popular at that particular moment, or even if the majority would not be prepared to recognize that right. And if a judge can be removed from office for making a decision that's unpopular, even if it's a legally correct decision, then we're all in a lot of trouble.
And this is all essential to the checks and balances system that we have.
I think that's true.
Here in Alaska, I recall quite a few years ago there was, for example, a bill that would allow the governor to make appellate level appointments. And then last year there was a bill that was introduced that would prohibit the Judicial Council from making recommendation no recommendations for judges that are up for retention. As an example, what's wrong with those?
Well, here's what I think's wrong with it. And maybe let me begin by explaining what the council does with regard to retention. I've gone a lot into what it does with regard to selection. Retention, it has a similar function. Alaska provides more information to its voters than any other place in the world, any other country, any other state. And I would urge people listening to this program to go to the council site, ajc.state.ak.us, and check it out. We poll all the lawyers who appear in front of a judge to find out what kind of job that judge has done. We poll police officers. We poll social workers. We poll jurors who have been in that court. We talk to court watch type organizations. We get the judge's decisions, a sample of the decisions, and we read those. We dig for any problems. When we see problems in off-election years, the council will call the judge in and say, we're getting these reports. We want you to know about this. We think you should take a look at what you're doing. I mean, we want judges to succeed. We want them to be good judges. We want them to be perceived as good judges. But if they get to the point where they're not, or they've got problems, the council has the power under the law to make recommendations to the voters to not retain a judge. It doesn't happen frequently, but it is a wonderful check to have on the performance of judges and to hold judges accountable, as they should be, as all public servants should be held accountable. The recommendation that the council not make any the proposal that the council not make any recommendations on retention would sort of cut the legs out under that whole system. I mean, the system is designed to make sure that judges are doing what they should be doing and that there's somebody that's monitoring their performance and then reporting to the voters. The argument was made that, well, the council can say yes or no, but they shouldn't do anything to publicize what they've done. And I think that's bad policy, and the legislature in the past has thought that was bad policy because it has given a budget to the council to publicize its results. And I think it would be bad policy to change that, although that is a statutory matter. The legislature could change it if it wanted to. I think it would be a bad idea because of the way that elections work these days. You start with the proposition that judges are under an ethical duty not to go out and campaign. In Alaska, judges can't go out and campaign unless and until there's formal opposition against them. Well, that might have worked 20 or 30 years ago when, it was kind of a slower age. But in the internet age, smart people that want to get a judge off or out of the judge's position don't start campaigning publicly months in advance. What they typically do is wait for a couple of weeks before the election, maybe 3 weeks at most, and they'll have a bunch of ad space bought. And all of a sudden, all of these ads will appear that such and such a judge is soft on crime, or such and such a judge did something that's just horrible. There doesn't have to really be any truth behind those allegations, but all of a sudden you've got this big campaign built up, and the judge, who can't do fundraising, who can't create ads, who can't do anything in his or her defense until there's organized opposition, all of a sudden now has a very short period of time to try to put a campaign together. And what the council has done, when that sort of thing has happened in the past, the council has placed ads in the newspaper and has said, we went through all of this analysis, this is what we found, and we recommend a yes vote, in the case where the judge had received a yes recommendation. And I think that's where that issue has come down now.
Let's focus on the retention process here. For example, there are 14 judges up for retention this year, and there may be as many as 41 up for retention in 2016.
Okay.
Although I don't think that all Alaskans will see all 41 on the ballot because of the way the ballot is constructed for each particular region.
Yeah, you just vote on judges that are in your region. If it's a statewide judge, then everybody votes.
During the retention process and the evaluation of judges, does the council, do they consider past decisions that the judge made or any potential future cases that might come their way, future decisions?
I don't think future decisions are considered because the council wouldn't have any way of knowing what future's coming in. Past decisions might be considered in terms of a retention recommendation only if you have a situation where, for example, the opinion is indecipherable. are incoherent,
No.
or suggests that the judge, isn't up to the task. I don't ever remember that happening.
But the ruling one way or another on a particular case?
Oh, no. I mean, the council isn't looking for rulings one way or the other when it's determining whether a judge is fit to serve. It's looking at, does the judge listen to both sides? Is the judge courteous to the litigants, to the lawyers, and to the individual litigants? Does the judge do his or her homework in terms of reading the briefs, and does this decision show that they've understood what the issues were and they're addressing the issues? The substance of a decision in terms of, well, they voted for the plaintiff or they voted for the defendant, no, the council doesn't consider that. It considers issues of competence in terms of researching the law, explaining the decision clearly, getting it out in a timely fashion, being respectful of all the parties in the court, those sorts of things.
How about the number of instances in which they've been overturned on appeal or bumped from a case?
The council gathers that information, or at least it did. I've been out of the game for 2 years, so I don't want to misstate what's going on now. It has done that in the past. I can't say that reversal rates have ever been a huge issue in determining a judge's fitness to serve, or whether a retention recommendation would be made. I mean, to put this in perspective, most judges get a yes recommendation from the council. A no recommendation is pretty unusual. And
What prompts that?
well, there was a judge a few years ago who had engaged in 3 or 4 things that were just highly inappropriate in terms of managing a caseload, signing bail orders in advance and giving them to one side in the case, I think to the district attorney's side. The idea being that I pretty much trust whatever you're going to say. I mean, that's just so far outside of what judges should be doing. Judges should listen to the facts in every case, should look at what the law is, and they should make a decision. The idea of signing orders in advance
Implies something that's predetermined.
Yeah, I mean, you're not judging and doing something like that. The judge had also made some fairly outrageous comments, and oh boy, my memory is going on me, but I think that they were of a sexist nature, and that was looked into, and there were a number of complaints that the judge hadn't acted properly, and the recommendation was to not retain him, and the judge was not retained. There was another judge, a very difficult case a few years ago that happened while I was on the council, of a judge who was just having emotional problems dealing with the caseload and dealing with co-workers, and they got worse and worse and worse, and there were lawsuits flying in all directions between the judge and other co-workers.
That actually prompted a lawsuit on the part of the judge's supporters, didn't it?
There was a lawsuit there were a number of lawsuits that came out of that. The judge eventually was not retained, and then he eventually agreed to drop his lawsuit and to agree not to apply for a position again. But I'll tell you, that was a tough case, because in terms of basic competence, I thought he had a lot going for him.
Yeah, I recall that lawsuit was just an opinion just came out of that
Right.
basically said that the council does have the leeway to issue their recommendations and opinions before an election.
Right. I think it's accurate to say that the council was upheld in all respects in that case, and I felt that was a good decision, and I'm glad the court came out the way that it did. That was a really sad case, though. But, I don't know historically how many there have been, but probably less than you could count on one hand. I mean, it's a very unusual situation for the council to recommend that a judge not be retained. And among other things, when the council's starting to get any kind of indication that a judge is having problems or kind of going off in the wrong direction or being tough on everybody unreasonably, as I said, the council meets with judges every 2 years. When the elections come up, a judge is either on the ballot or is going to be on the next one, but it looks at all of the judges that it can, and it tries to monitor what's going on so that we can have the best judiciary in the country.
And there are other things that are considered temperament, whether he or she has a good temperament, life experience, legal experience, that sort of thing.
Those things are considered. You're asking about retention now?
Yes, in the retention process.
Sure, temperament is real important in retention. Well, because it's important that people be treated fairly, and it's important that people have the understanding and the belief that they've been treated fairly. And I suppose it's possible for somebody as a judge to yell at everybody all the time, to be abrupt with people, to appear as if they're not giving their arguments the due consideration that they should be giving them, but be a fair judge because he or she has actually read every last thing and heard every last thing. But it doesn't usually happen that way, number one. And number two, even if they are doing that, even if they are reading the briefs and listening to the arguments and considering everything, if they appear not to be doing that, you don't have the appearance of justice, and that's important. I don't think there's ever been a recommendation that a judge not be retained because they had what appeared to be a bad temperament, but otherwise they were great. But it's one indicator you want to look at.
I want to jump back to the subject of politics and the process.
Can I say one more
Sure.
thing on that last point? I was a defense attorney, and defense attorneys, of all attorneys, have the right to preempt judges in Alaska without giving any reason. It's sometimes a controversial thing, but that's the way it is.
When I refer to the bumping process.
Exactly.
Right.
And I was a public defender, and I had a client in a disorderly conduct case, lowest in those days, Class C misdemeanor, whatever, it was the lowest one. It carried a possible sentence of 10 days in jail and a $300 fine. This was in the 70s. I had a client who did not want a local judge, who had a reputation for having a terrible temperament. And I said, we've already agreed that you're going to plead guilty, because he was guilty. I said, this whole case is going to be about the sentencing. And this judge, for all his fire and brimstone, is really kind of a weenie of a sentencer. He was a light sentencer. I said, he will yell at you, but he'll give you 10 days, 8 suspended or something, and fine. He wouldn't be fined. He was a public defender client. He said, I don't care. I don't want that. I won't say what he called him. And I said, okay, you're going to get either Judge Henry Keene from Ketchikan or Judge Robin Taylor from Wrangell. And I said, both of those guys will give you a tougher sentence than the judge that he didn't want to have sentence him. He said, I do not care. I don't want that guy. So I filed a preempt, which I did not like to do. I really did not like to preempt judges unless I thought that a judge was not going to be fair. I didn't want to do it, and I tried to talk my clients out of it. We did it. We went into court. We got Judge Keene, who was a gentleman of a gentleman. He was wonderful. Mr. Carpeneti, how are you? Welcome. Mr. Defendant addressed him by name. When it came time to give his allocution, he did. He gave his excuse, whatever it was. And Judge Keene then very politely and kindly sentenced him to 10 days in jail, none suspended, and a $300 fine, none suspended. I mean, the absolute max. And, to the extent that I was affected, I was crushed as we were walking out. I thought, I did as badly as I could have done. And I was feeling terrible. And he whacked me on the shoulder as we were walking out, and he said, you see? And I said, you fool, what are you talking about, you see? You just got the maximum. You got a $300 fine for a public defender client, somebody who has no money to hire a lawyer. And $300 in the 70s was a lot of money. Yeah. And he said, I don't care about that. I can do 10 days in jail standing on my head. And I don't have the money. They're never going to get it out of me anyway. That guy treated me with respect. And it was like the scales fell off of my eyes. I thought, it's really important to all of us that we feel that we've been listened to, that we're treated with respect, that we have something to say, the person will take it. And I'm sure Judge Keene did all of those things. But when it came time to give a sentence, he was a tough sentencer. And it was such a lesson for me. I mean, I thought about that 30 years later when I was on the bench thinking, this person is kind of a fool, but I've got to listen to what they're saying, and I've got to make sure that they understand that I'm listening to what they're saying. And, every now and then they say something that convinces you. And so I think it's really important, when you talk about judicial temperament, that it goes a long way towards defining how people think they're being treated in court, how they are being treated in court. So I think it's really important.
Let's go back to the politics issue. Judges usually don't take stands on political issues or issues before the legislature.
Pretty much never.
Yeah.
There's a narrow exception in the Code of Judicial Conduct.
But you did that this year on Senate Joint Resolution that was proposed by Senator Pete Kelly.
Well, yeah, but I'm not a judge.
Not anymore, right?
I am not a judge anymore, and believe me, it felt like, somebody walking to the edge of the precipice and then just stepping off. I mean, it was very, very unusual. But
it would have modified the way that the council is made up, as far as more lay members.
right.
And his objection to the way it's done is that there wasn't enough regional representation on the council. He was also concerned that perhaps there might be a perceived conflict of interest with the Chief Justice on the council making the particular votes. And we actually have a clip from the recent legislative session in which that came up on the Senate floor. Let's take a look.
Sure.
Another problem that we saw was that the attorney members of the Judicial Council are not confirmed. They're not elected by the governor, they're not elected by the people of Alaska. They're not appointed by the governor. And once appointed, they're not confirmed by the legislature. Completely isolated from any kind of democratic process, from any connection to the people that we represent. It's kind of a flyer. If you were in the shooting sports, you'd look at something like this and you'd call that a flyer, and that's where you're looking at the score of a shooter, and you've got a whole bunch in the 10 ring, and then there's this one way off on the white paper, and you call that a flyer. Well, that is kind of a flyer in our form of government. As Americans, we don't do that. We don't have a guild appoint people to choose an entire branch of government, or to have such influence over choosing a branch of government. And if we did, certainly we would say, these people need to go before the legislature to be confirmed. There has to be that thread back to the people. We do it when we choose our Supreme Court justices of the United States. They have to go sit before the Senate. They have to be confirmed. They have to be scrutinized. They have to be held accountable. We don't do that.
What's your view on that?
Well, with regard to attorney members not being confirmed, that was debated at the Constitutional Convention. And here's what the chair of the Committee on the Judiciary, George McLaughlin, said. If you require a confirmation of your attorney members by the legislature, you can promptly see what will happen. No longer is the question based solely on the qualification of the candidate for the bench. If political correctness enters into the determination of the selection of those professional members who are to be placed upon the Judicial Council, the whole system goes out the window. All you have is one other political method of selecting your judges. Now, I mean, they thought about it and they debated it, and for that reason they said, no, we shouldn't. This isn't the political side. The political side comes when the governor makes the determination. That's the second half of the process. The first half of the process should just focus on the merit involved. And I think that's the better policy choice. It was the one that our framers made in 1955 and that the people adopted when they adopted the Constitution, and that the U.S. Congress agreed to when it affirmed that. So it's an argument that can be made, and Senator Kelly has made it. It didn't win in 1955, and for the reasons it didn't win, I don't think it should win now. I'd make a second note. You know, you can't pick and choose. You can't pick the parts out of the federal system you like, senatorial confirmation. By the way, in the federal system, it's just the Senate, it's not the House. The suggestion here was both the Senate and the House, so it's not the same. But you can't do that and leave everything else out. I mean, the federal judiciary, they don't go through retention elections every 4 years or 6 years or 8 years or 10 years, as Alaska judges do, depending on their level. They're judges for life. Again, that was a decision that was made. We're not going to go to that. We're going to go to a system that's a little more finely tuned towards checking periodically on the judges and having the people vote yes or no. But to get them on there, we're going to just look at the merit. So I don't think it's it's an argument. I don't think it's a persuasive one. You also mentioned in the setup, before you played Senator Kelly's remarks, about the conflict of interest argument. And I will say, I testified 4 or 5 times, and every time I said, I don't get this conflict of interest argument. I mean, it makes no sense whatsoever. At the time, I was on the Supreme Court. My professional job was to look at what trial judges did and say, yes, you're right, and affirm them, or say, no, you're wrong, and reverse them. Now, was that a conflict of interest? I don't think so. That's what you do as an appellate judge. So how is it a conflict of interest for me to sit on the Judicial Council and once in 3 years, or twice in 3 years, be put in a situation where I had to say, yes, I think this name should go through to the governor. No, I think this name should not go through to the governor. That is when there's a 3-3 split. It doesn't make any, it's not a conflict of interest. It's part of the job. It's what you do. When you're the Chief Justice of the Supreme Court, you break a tie if you have to on the Judicial Council, but there's no, I mean, when I made that phone call to the Fairbanks judge that I had voted no for, I didn't feel a conflict of interest any more than I felt if I would have signed an opinion reversing him because he made legal error in a decision. And when I, at an earlier time, broke a tie to send somebody through to the governor, I wasn't in a conflict of interest. It wasn't as if affirming a decision that somebody makes puts me in a conflict. It just doesn't make any sense.
We're almost out of time,
Sure,
but
sorry.
we wanted to wrap up here by letting Alaskans know, voters, where they can get the information regarding the particular judges that may be on the ballots. There is the website that you mentioned, and I believe there is a kind of a better website that might be a little bit easier, knowyouralaskajudges.com, that kind of goes to the same place.
Right, yeah.
And also the voter pamphlet that has all the information that you mentioned earlier in regards to all the different information. What are the things that we are seeing here as far as the numbers here? These are the ratings that you mentioned?
Right, those are the poll results from, can I grab it a little closer?
We're just about out of time here.
Poll results from attorneys, peace officers, jurors, and court employees, as well as the candidate's statement.
I'm sorry, we're all out of time.
Okay.
That's all the time that we have for this segment of Forum at 360. We've been speaking with retired Alaska Supreme Court Justice Walter Carpeneti. Thanks a lot for stopping by. I really appreciate it.
Thanks for having me, Matt. I enjoyed it.
You can visit our website at 360north.org. Thanks for joining us.